let me make sure that, you ready? Okay. Most of you know that I'm Chuck Thompson. I'm county attorney for Montgomery County. There are some of us, some people here who are from other counties, and I really appreciate the fact that you're here to join us. One of the things that I've tried to do since being county attorney is to try to recognize that all of us in the practice of law can learn how to do our jobs better. And one of the great opportunities in learning that is to learn from people who are truly experts in one area or another of the practice of law. And today it's really my great pleasure to have with us Charlie Ryan, who is a person that if I gave an introduction that was due him, we would be here for hours. So what I'm going to do is to be a little bit more brief than that and to say that Charlie is the person who was the youngest ABA president ever, is the person who founded the National Institute of Municipal Law Officers many years ago and served as its general counsel for 50 years, that had a person who has argued any number of cases before the Supreme Court, as you can see in the materials that he's presented here, and one, what I think is one of actually a number of major cases at the Supreme Court, but to me, Baker versus Carr, which is a case that I believe did much to change the framework of government throughout the United States and allowed for reapportionment to take place and allow cities and the more populated areas to have their due in their state legislatures. So without more ado, let me introduce Charlie Ryan, a man who I have great admiration for.
I have been talking with and working with municipal attorneys all over the nation for more than 60 years, so I feel kind of at home anytime I look out there and see municipal lawyers, because they have been my life. Chuck asked me to talk about effective modern appellate advocacy, and I thought that since I'd had some experience in the Supreme Court, I would talk about the overall situation as it is in the appellate presentations today, when it's really a question and answer rather than what it used to be. In 1939, when I made my first argument before the Supreme Court of the United States, Charles Evans Hughes was Chief Justice, and just to look into that huge man with that mustache would scare any lawyer to death, and I had to be specially admitted to argue this case. I was representing cities, and they were challenging the validity of the COLAC. I won't go into all of those ramifications, because if I start talking about one case, I'll take all the time that I have up. I'm a lawyer like everybody else. But thank goodness I survived, and the result was that the coal commission that I was fighting was wiped out of existence by federal order of Franklin Delano Roosevelt, so that the 9 old men, as he called the Supreme Court, couldn't pass on the constitutionality of the act that I was attacking, because it fixed the price of coal without any notice of hearing. Now, I'm going to talk mostly about the big change in appellate advocacy in the last 50 years. It used to be, when you went to the Supreme Court, you could file a brief of unlimited pages, 1,000 pages for that matter. Not many people did, but some of them did. And you were given 1 hour to each side to present oral argument. And now you are limited to a 50-page brief, and you have 30 minutes for the oral argument. And in that oral argument, as I will come back to a few times, you're lucky if you get half of the 30 minutes, because the questions from the bench rain down upon you. Now, I think that that is a good thing. I'm not one of those who think that it's the justices should just sit up there and listen, because it shows that they're very much into the cases that they're considering. If they've read the briefs, why then they know what is bothering them, And I would really like to hear from them what's bothering them in the argument rather than to read it in their opinions later. And so you have a chance, it's a great opportunity to educate them in the points that you're trying to make. Now, I have in my early days followed the usual procedure where you reviewed what had happened in the court below. You reviewed both the procedural events and the fact-finding and things like that. But now, when you stand up there and you know you've got 30 minutes, and Lord knows how many of those minutes you're going to get because all the questions they ask are taken out of your 30 minutes. So I would say to you that an opening of an oral argument in the Supreme Court in the United States right now goes something like this. Your name is called by the Chief Justice. You stand up there and you say, Mr. Chief Justice, may it please the court, the issue in this case is. And in some instances, you get a chance to explain what the issue is, and some you won't. Now, one of the cases that I selected to show how you can best proceed up there, and in the prepared text, which I'm not going to read to you, you can read that anytime, and gives you more detail. I selected probably one of the most difficult cases I ever had to argue, the Mobile case, where district court had held, and this was in 1980, all the uproar was going on over civil rights, and I had won Baker versus Carr, and all the reapportionment was going on. And Mobile had a commission form of government, 3 elected commissioners, and each one of them having certain departments assigned to them, but everybody in Mobile had an equal right to vote for those 3 commissioners. The district court held that the commission form of government was unconstitutional and had to be abolished completely in order to give the 1/3 of the residents of Mobile some kind of an opportunity to participate more fully in municipal government. So I thought I had to, in appearing before the Supreme Court and telling them what was involved, so state the case or the issue that they would understand that they had a lot of problems. I had to argue the case twice, but my opening statement to them, and this is one of the few things that I will read to you because it kind of tells you what I would like for you to understand about appearing before that court. I said, this case presents a question whether the Equal Protection Clause of the 14th Amendment requires the abolition of the Mobile Commission form of government elected at large. This is the first case involving a state or local government in which the entire form of government, not just the manner of its election, has been held unconstitutional. Mobile is 1/3 black. The district court held that only the abolition of the commission form of government in its entirety could provide blacks a realistic opportunity to elect blacks to the city governing board. Now, the Supreme Court, I knew, was in kind of a quandary because these cases were coming at it from all different ways, and I think that in outlining the real difficulty of the case and how unusual it was at the very opening, that I got their attention. And after 2 arguments, the court finally, in a plurality opinion written by Mr. Justice Stewart, said that where the character of a law is readily explainable on grounds apart from race, you would nearly always be true, whereas here, an entire system of local government is brought into question. Disproportionate impact alone cannot be decisive. The court held really that in a 14th Amendment equal protection case and the 15th Amendment, you had to prove discriminatory intent, and discriminatory intent hadn't been proved, so they sent the case back on remand. Now, the most famous case that I ever argued up there, and I only mentioned cases I've won, was Baker versus Carr, and that is the reapportionment case. I spent an awful lot of time in trying to figure out just how to approach that case and the issue in it. And the first time around, I did get out the issue before Mr. Justice Frankfurter jumped on me. And he was kind of mild at that time. So then we go through an argument when he was making clear that his Culver case, which he had held, that the court should stay out of reapportionment because that was a political ticket that the court shouldn't enter. And then somehow or other he persuaded them to order re-argument. And I was sitting in the Supreme Court beside Archie Cox, the Solicitor General then, who was going to argue as amicus curiae in my behalf. That had been announced, and so we knew, and Justice Frankfurter knew, that the Solicitor General had joined my army. And so Archie and I were talking about what was going to happen. He said, well, Felix, he and Justice Frankfurter, being law professors at Harvard, he called him by his first name, Felix will be after me from the word go. He'll chew me to pieces. He had all summer to get ready. And I said, well, he's got me for an hour before he comes to you. I bet I don't get beyond Mr. Chief Justice before he starts his first question. Well, about that time, the court came in, and Chief Justice Warren said, Mr. Ryan, I stood up to the podium and I said, Mr. Chief Justice, and may it please the court, and I heard a noise over towards Justice Frankfurter, and one of the things you learn is, if you hear a noise from one of those justices, you shut your mouth right then, and let them say anything they want to. And he said, Mr. Ryan, when we take into consideration constitutionality of anything, we take into consideration history. And he went on, it seemed to me, I thought he was about to take up my entire hour. Bang, 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 bang. He was making points that he was trying to get across, I think, to his brethren. There were no ladies on the court at that time. But he was trying to convince them. And to me, it meant that he hadn't done so well in the conference after the first argument, and that he was losing his case because he was up high. And I mean, when Justice Frankfurter got up high, he was up high, and he came at me, and he went on and on and on. And finally, he had to stop and catch his breath, and he said, Mr. Ryan, I have asked you a whole lot of questions, and you have just stood up there and looked at me and smiled. And none of you answered. And I said, well, and he kind of paused a little bit, and I said, Mr. Justice Frankfurter, with all due respect, if you will give me the opportunity to say something, I will answer all your statements in one word. He slammed the brief down, and he said, did you come up here to make an argument? If so, make an argument. And Chief Justice Warren leaned over and said, Mr. Justice Frankfurter, why don't you give Mr. Ryan an opportunity to tell us what that word is? He said he would answer you in one word, and we'd all like to hear the word. And so he kind of pulled himself back from the bench a little bit, and I said the word is equality. The 14th Amendment contains it, and this court is bound to enforce the 14th Amendment. And that's the duty of the court, and that's why I'm here. He said, don't tell me my duty, don't tell me my duty. So I think that those of you who have read Supreme Court arguments there, printed and reprinted in various places, you'll have to agree that I really got to working over from that time on. But I really, for example, not only did I argue that the entire state government picture was a mess then, because in the various states, the had been a great urbanization way. People had moved into the cities, and I was representing the cities in Tennessee, and particularly Shelby County and Memphis. And in 1901, when last time there had been a reapportionment, they gave Memphis 7 members of the legislature when they were entitled to 8. And now the population had flowed more into Memphis, and they were entitled to 15. And so Justice Frankfurter tried to get me into all kind of hypothetical questions, and now was the first reapportionment constitutional? Do you say the first one was unconstitutional because it was one person out of whack? And I said, well, that might just barely pass, but when you get to 15, I can't say that that is constitutional, and I don't believe anyone else can. Well, I expected him to say, well, I can't, but he didn't. And so I poured it on about, and we had really amicus briefs from covering most of the states in the nation about how they had not reapportioned. And so I finally finished with him, and of course, as you all know, I won the case I got all the votes except one. I didn't get Justice Harlan. And that was the only one that Frankfurter got. One of the questions a lot of people ask me since then about Justice Frankfurter was because he was so unfriendly to you or what, that he chewed you up so. And I said, well, he was very nice to me when I was president of the Order of the Coif at GW. I marched up there and asked him to be the speaker at the banquet, and he accepted. And I think that's the only outside speech that I ever know of that Justice Frankfurter ever delivered. He even said some nice words about me in the Supreme Court, but that was before Baker versus Carr. Now, so I say that sometimes you get a chance to state what the issue is, and if you get a chance to state the issue, you should state that issue giving your view of the equity, the fairness of your decision in your favor, and state your best facts in that issue, because that stating the issue really begins the argument and sets the tone for the argument. And you should also state that issue real slow, because if any one of those justices want to disagree with you, it's wonderful to have them disagree right then. That might lose you one vote, but you can at least begin to size up the court. And so under this current business of question and answer argument, the lawyer really knows what's bothering the court. And if you can satisfy the court on what's bothering it, you have a chance of winning your case. If you can't satisfy them, why, you haven't got a chance. So oral argument, I think, is much more exciting. It requires much more preparation. You have to be more concise in your brief and more thoughtful, and you have to edit it down to those 50 pages. The one thing you can be sure of is that they have read the briefs. Back when I first started up there, you never expected them to have read anything. But now you can expect them to have read the brief. Now, I think that as I go along here and I say I'm kind of rough hewing out something, I'm not going to read you what I wrote in the paper. I want to talk about a few points that I've encountered in my experience and might be helpful to you, and you maybe have already encountered them. But the next thing I want to talk about is the danger of a divided argument. My example is the National League of Cities case, where I had to argue that one twice, and the governors of the United States said they should have someone of their own helping to present that case, since we didn't seem to win on the first round. And so they selected a distinguished governor from the West who had been an attorney general, and he naturally wanted to go first because of his prominence. Well, he went first, and when he had been up on his feet a little bit, Justice White asked him, what about proprietary and governmental? Would you draw the line and say that proprietary functions can be covered by the Fair Labor Standards Act, but governmental cannot? And he said, well, that sounds like a pretty reasonable approach or something like that. passed on. And then when Justice White got me next, he knew that I had been saying that it was a question of power, that it depends on who the employee gets his check from. If he gets a check from a county or a city or a state, he's an employee, and the federalism issue, which I was pushing, involving the 10th Amendment, in fact, the whole Constitution, makes that unconstitutional. And so White started and said, "Do you agree with him?" Well, I stalled a little bit. While I was stalling, my son Bill, who always went up with me on these cases, he handed me a note. Justice White said, "Oh, Mr. Ryan," and he was really kidding. Sometimes they get a little funny up there. He said, "Your brains has handed you the answer. You better read it before you answer my question." And I said, "Well, I'll hand it to you, and you can read it to everybody here." "Oh, no," he said, "I'm not going to fall for that. I'm not going to fall for that." Well, actually, Bill's note was, "For heaven's sakes, if we get in that bog, we'll never get out." Tell him as a matter of principle that you feel that that is too indefinite, too uncertain a standard to apply any statute, because there are hundreds of cases on what is governmental, what is proprietary all over the nation, and they disagree as to what is proprietary almost universally. But anyway, I won that one 5-4, and then I'm sure you also know, 9 years later, in a case involving bus drivers from San Antonio, the court reversed 5-4 because it said it was too difficult to pass upon whether things were proprietary or hereditary functions of local and state governments, and therefore they just wiped out the complete exemption of all state and local employees under the Fair Labor Standards Act. I think I agree with the Chief Justice Rehnquist that the court will sooner or later reverse that. But it shows that this governor, who hadn't buried himself, he hadn't really thought the thing through. But I met with him 2 or 3 times, and he was very, very busy. And you shouldn't appear in a case like that, in a court like that, unless you have submerged yourself so in that you know all the facets of it, and you can handle an argument or a question like that. And I think that the mistaken divided argument in that case brought on the Garcia case, where they wiped out the exemption. Now, in that court, there are a lot of other dangers, and I'll just mention 1 or 2 of them. One is, don't read anything to the court. Now, they have a rule that prohibits it, but back in the days before they had that rule, I went up to argue a case involving Phillips Petroleum, and the issue there was whether independent producers and gatherers of natural gas who were supplying natural gas to Chicago and Detroit and New York, all over the country, should have their rates regulated with the Federal Power Commission. They tried first to get an exemption from the Federal Power Commission power. They steamrollered, I mean the so-called independent producers together. They got a bill through saying it didn't apply to independent producers and gatherers of natural gas. And I went to the White House, and I appeared there to argue for the consumers, and President Truman listened to me and vetoed it. And so then I go to the Federal Power Commission and persuade the Federal Power Commission that it didn't have the power. So then we had to go through all of that, and finally we got up into the Supreme Court again. And just before the argument, a new Solicitor General came into the picture, and his side, as he told me later, said they thought that the importance of his office and everything required that he argue that case. He didn't have time to study the briefs or write the briefs or study the record. So they wrote him an argument, and the court sat up there almost in shock and listened to him for 45 minutes. That was how much time you got. And at the very end of it, he said, "And I submit that this court should be generous in freeing these small little independent producers and gatherers from the control of some federal bureaucracy, and a few other words like that. And he sat down, I got up, I said, well, I have to disagree with the Solicitor General. These are not small, little, poor, independent producers and gatherers. Phillips Petroleum earns more than $140 million a year. In addition to that, it gets depletion allowances, and they operate in all the western states where natural gas is produced. And so Chief Justice Warren, who'd come on the court, this was 54, he'd just come on the court, and he liked to be referred to sometimes as the Big Swede. The Big Swede approached things rather methodically. He said, Mr. Ryan, just let's slow down a minute. You tell me where those figures are in the record. And I told him, and he very slowly wrote them down, and he said, now, that takes care of Phillips. Let's go to the next one. So I told him where it all was. And so when the argument was over, the governor of Tennessee came steaming over to me and said, Mr. Ryan, you insulted the new Solicitor General. I said, I did? How did I do that? Oh, you disagreed with him. I said, well, that's what we're up here for. And he did his job and I did mine. I said, let's ask him. I said, Simon, come here. It was Simon Soboloff, a former city solicitor of Baltimore, great friend of mine. I said, Simon, come here. The governor says I insulted you. He said, how did that happen? He said, I disagreed with you. He said, oh, well, I've never heard of such a thing in my life. He said, look, I'm so new, I don't know how to find the office of the Solicitor General in the court. And he put his arm around me and said, you come take me over there and show it where it is. But anyway, in that instance, of course, the interests were lined up back of the Eisenhower administration. And so they steamrolled another bill through. And that came up in the White House. And I went over there to argue that Eisenhower would veto it, and the natural gas industry was just sure he wasn't going to do it. And the Oval Office was jammed with people. Well, when it was all over with, I did veto the bill. And so they never forgave him. He was in his second term, but they were not going to be able to bother him very much. And now it's these things that ancidental things that I love to talk about almost as much as I do the issues in the case. But I would say to you that the do's and don'ts of what you do in any court, and particularly in the Supreme Court, are a long list. There are many books written on the subject. But I give you one recommendation. Don't ever criticize by name a judge of a local court that you're appealing his decision. And particularly don't say anything disrespectful of it. Again, I got into the Supreme Court in a case where I was representing not cities, but a client of the city attorney of Los Angeles who sold vitamins and minerals. And I had this was in the middle 1940s, involving the federal rules of civil procedure. I had a 3-judge court. I was challenging the constitutionality of their making seizures of this company's product without notice or hearing. And I said that under the new federal rules, I was entitled to hold records of the Food and Drug Administration. Well, instead of go before a judge who was a member of the 3-judge court where I had a declaratory judgment complaint filed, and he decided that both sides had to give all their records under the rules, and the federal government did something unique and unusual. It filed a petition for a writ of prohibition and mandamus, prohibiting this judge from ordering them to produce their records. And the day that was filed in the Supreme Court, the court set it for argument 1 week from then and required both parties to file their briefs by that time, and the case would be argued on that day. And of course, this was a big thing, and then these rules And the federal government was arguing it didn't apply to them at all. And we all thought that they did. I worked on those rules and understood they did. Well, anyway, we get up there to argue it, and the Solicitor General, not Simon Sobelaw, Philip Perlman, Baltimore, he started out his argument this way. He says, no, this is an unusual case. We're taking an extraordinary path here because we think these rules don't apply to the federal government and we don't want to open the floodgate. And he says, and there's another thing that's unusual. You know, the judge who entered this order has personal problem. Well, I thought Chief Justice Vinson would jump over the bench and strangle him. He said, we don't welcome such arguments in this court. If you want to make an argument, talk about the decision of the judge. Don't talk to this court in those tones about any judge. And, well, as Phil said to me later, he lost his case just then because all I had to do was stand up and say, look, the only reason they don't want to give us these records is that will prove our case. And when I got back to my office, it seemed like I'd hardly got my chair warm when I got a call from the clerk of the court. And he said, I want to read an order of the court to you, and you're going to get shocked. And I said, well, I hope not. And he said, it's just one line. The petition for writ of prohibition mandamus is denied. Justice Douglas dissents. So the judge was Bennett Chan Clark, and of course everybody knew that he was an alcoholic. He was a famous senator from Missouri. But don't criticize judges personally, and don't criticize your adversary. I've heard justices of that court in private conversation said, well, so-and-so castigated so-and-so in an argument before the court, he must not have had a case. So they figure if you don't have anything to talk about except something that irritates you about your adversary, a lawyer, keep it to yourself, because they conclude that you want to waste your time on him. You don't have any case to talk about. So you always should make tactical references to your adversary and to judges. And answering questions, I've always found it was a good idea to say that the answer to your question is yes or no, and then my reasons are so-and-so. Because I've sat up there and listened to a lot of people argue a case, and the judge asks a question, they tell him what the answer is, but they don't say yes or no. And when he gets all the way through, sometimes the justice will say sarcastic, I take it the answer to my question is yes, could be no. And so tell him definitely the answer is yes, and my reasons are so-and-so. Now, in the hypothetical area, I'll only say to you that when you are in the Supreme Court, you can expect hypothetical cases involving things that have absolutely nothing to do with your case. But you better not say to that justice who gives you a hypothetical, oh, that's relevant here, I don't have to answer that or something, because that's an insult to some of the other justices who are going to ask the same kind of hypothetical stuff. So take it in stride, answer it the best you can, but don't refuse. Now, and finally, when you get all the way through with your argument, you trying to make your points that you had in that long outline that you had laying in front of you as answers to questions. Try to wield into your answers to questions the things that are in your list that you must cover to win. And that is the technique that in modern advocacy that's grown up all over the country, because the other courts too have cut down on pages of briefs and on time of argument. And so train yourself to fashion answers to questions in that way, so that they really forward your case. And I had one illustration I wanted to give you because I'm always proud of it. I represented the motor carriers in the eastern part of the United States in a big fight with the West carriers, where the eastern carriers were trying to get across the river. I'm not going to go into all the ramifications of it because the case was tried for more than a year before the Interstate Commerce Commission, and it decided for the eastern carriers. The Westerners took that case to a judge who they knew that was friendly to him because he'd been a congressman down in Arkansas, and he held that the ICC had been arbitrary and capricious. And so in that case, I made my argument, and I saved half of my time to answer this very flamboyant lawyer who was screaming about the arbitrariness of the Interstate Commerce Commission. And then when he finished his argument, it was time for lunch. So we went out for lunch, and the lawyers, there were a lot of lawyers there representing motor carriers from all over the East, said to me, "What are you going to do on rebuttal?" I said, "Well, let's sit down and get our lunch first." And then one of them said, "Before you do that, I want you to tell me, what's Justice Douglas doing up there?" I said, "He sits up there and writes, and he writes, and he writes, and he writes. He doesn't seem to pay attention to anybody or anything." And I said, "Well, he's either writing a letter to his latest girlfriend or he's writing a decision in this case." I hope it's the latter. And they said, "Well, tell us what you're going to do." I said, "Well, I'm going to stand up and say that the lawyer for the West made a fatal concession, and this case is over." He admitted during the course of his argument, when the justice asked him, was there substantial evidence to support the ICC's finding that public interest and convenience required that the Easterners be allowed to cross the Mississippi and serve the entire United States, because that was in the public interest and for its convenience. And this court doesn't decide factual things. It depends on the agencies that are supposed to decide facts below there. Many, many cases in which this court is so held. And so unless you have questions, I rest my case. He's admitted himself out. And so it took me about 30 seconds to say that, but I had the maddest bunch of associate counsel in my life on me. They said, you just blew the whole case away. And I said, "Well, I don't think so." And I'm telling you, I was really happy when about a month later they came down with, I think, the only unanimous decision of the entire term, 9-0. Douglas wrote the opinion in our favor. He said they admitted that the ICC was right. Now, above all, while preparation is really the answer to winning a case in appellate courts, just like it is in every place. And I'm sure that all of you in your work realize that you have to do an awful lot more work now because of the limits that have been imposed on the legal profession by the courts. They're swamped, and really I think we're getting justice better and faster because of the new rules, limiting briefs, limiting oral argument, and then the justices are participating. They're really a part of that argument. You're not up there to give them some oration. So I hope you all get to argue a lot of cases in the appellate courts, and I hope you enjoy them. Now, Bill, he generally, in my relationship with him, has to argue the cases in the other courts other than the Supreme Court, and he's represented both the federal government and local government, and he has a few words he can say about that type of argument. Thank you.
My assignment has been to talk very briefly about the aspects of oral advocacy in which representing an appellee, especially a government appellee, is different from the kind of things that you've heard about so far. We put 3 of them in the paper that you have before you. I think, though, that I can illustrate the problem that a government appellee has by taking this presentation this morning as my example. Think of me now not as someone who's giving you part of a talk on oral advocacy, but as the lawyer for the appellee. I've been sitting here patiently for the last half hour, 45 minutes, listening to the argument by the appellant. And that argument was given in just the fashion you heard, with humor, with liveliness, with sincerity, by the most preeminent Supreme Court advocate of our age. What am I going to do as the lawyer for the appellate? I could try to imitate that, but what would I say? What is the theme of any case on behalf of any appellee? Leave aside the legal issues in the case. Leave aside the factual setting of the case. The theme for any appellee would sound something like this, and I'll deliver it in the same style that an appellant would give the argument, but it's the appellee's theme. May it please the court. A tremendous justice was done in this case. Good prevailed, evildoers were punished, and in sum, we urge the court to sit on its hands and do absolutely nothing to disturb the result in the court below. You have to say that theme in a very different tone than you would if you were arguing the very same case yourself as an appellant. And we tried to give 3 ways of setting that different kind of tone in the written materials that you have. Perhaps the most important is to stress the standard of review, because that helps cool the case down and calm the court down, and is an advantage that the law gives you to make it harder for the Court of Appeals to reverse. I'm talking about the difference between 2 different kinds of statements. Take this statement as an example. The evidence was admissible. We maintain, Your Honors, that the district court properly admitted this evidence. That is the way that would occur to everyone to state the issue. But see if this isn't more effective. May it please the court. We maintain that the district court did not abuse its discretion in admitting this evidence. Same issue, same evidentiary ruling. But now you've reminded the Court of Appeals that if it's going to reverse on that evidentiary point, it can't merely disagree with the trial court. It has to come to the conclusion that the trial court abused its discretion, and it has to be willing to write that down and put it in its opinion. And that is a very harsh thing for any panel of 3 judges to say about one of their colleagues in the court below. That is an advantage that the law gives you through the standard of review. You ought to use it every chance you get. You ought to use it in your brief. You ought to use it in your oral argument. There's one final thing that I want to mention briefly, because we do want to leave time for such questions as you might have. And that is a technique of answering a particular kind of question when you represent a government. When I went around the country on behalf of the federal government arguing in federal courts of appeals, this kind of question occurred with surprising frequency. And it is a question from one of the members of the panel that you're arguing before about the operation of the government agency or the government program that you're representing that has nothing to do with the facts of your case. It's not in the record, it's not in the briefs. When I represented the federal government, I had a number of occasions to appear before the First Circuit up in Boston. And every time I argued a case up in that court, Justice Breyer, who then was a judge on that court, was on the panel, which I suppose isn't surprising. There were only 4 judges on the entire court. In every case, Judge Breyer had a question that was like that. The questions were always on the line of, how long has this policy been in effect? How was this policy developed in this agency? How many cases have been adjudicated under this policy? Has anybody gotten relief under this policy? Things like that. And the answer always is, Your Honor, that's not in the record, but here is the answer. Many appellees, many government lawyers, aren't quite sure whether they're permitted to provide information that's not in the record. And the answer is, you are permitted to do it when it's in response to a question. You may not initiate that kind of information that goes beyond the record, but you're, I say, obligated, not just permitted, obligated to answer every question that a judge asks you. You have to find out the answer to the question, of course, by trying to guess what kind of questions like that you'll get from the judges and talking to the administrator a week or 2 before the oral argument. Say, tell me how long this has been going on, because I think it might come up in the oral argument. What you gain by giving an answer like that is to demonstrate not only to Judge Breyer, but to his two colleagues on the court, that you have come to his city seriously to give a serious job on this case. And you want very much, on behalf of your government, to provide all information that might be even remotely of interest to you. Now, I must say that I never had a case where the opinion had anything to do or mentioned in any way this far-afield kind of information. But I think through your willingness to provide it, and you can say, Your Honor, in preparing for this argument, I asked that kind of question to the administrator. The administrator's answer was as follows, and give it that way. That shows all three judges on your panel that you have nothing to hide, and you want to provide full information on any subject that they have in mind. And in the similar spirit, we would like to provide answers to such questions as you might have, anything that we can.
I guess it's I think maybe the best thing to do is we'll get back up here, and if you have questions to ask Mr. Ryan, plural, please feel free to do that.
I warn you, I don't hear too well if you have any questions. I'll try to answer, and I have my brain on the right, so he'll answer if I can.
Any questions?
Well, that's wonderful. Let's stop right quick. Never faced a group of lawyers before who didn't have an awful lot of questions. When I was president of the American Bar Association, they were always adopting some rule or something, and it was very contested and so forth. And I'd travel around the country, and if I opened myself for questions, boy, I really got them. Well, thank you very much. I enjoyed being here with you, and I hope that you, from the reading of the text and from the few comments I made, can benefit. Thank you.
Thank you, Charlie. Thank you. Thank you all very much for coming. I certainly appreciate it. I hope all of you can take some of this back and learn from it as I have. Thanks again. Let me sit around, go back to work.
Is he a slave driver like that? I remember a case involving Representative United Fruit, a case where the United States Relations Board was trying to apply the Fair Labor Standards Act to employees on ships owned by subsidiaries of United Fruit, but registered in Nigeria. And I also had the Solicitor General on my side there. And the government was divided on it. But it was a very interesting case. And I wanted that they had no jurisdiction over foreign seamen aboard a ship registered under another flag, so the law of the flag. In fact, I went back 4,000 years and found that the law of the flag had governed employment status of employees on board ships all that time. And I don't remember now how I found out about 4,000 years. That was very impressive to talk to Clark. He wrote it.
Well, that's why I was interested in international law, it's maritime law.
Yeah.
Thank you very much.
All right. I'm surprised no questions. Well,